Name?
Terrence Smith.
Thank you.
Your Honor, we'd ask the court to set a jury date in this case, and I'd like to argue bond.
Jury final settlement conference will be set June 5th, 2026, 9 a.m. Jury selection, if necessary, June 8th, 2026 at 8:30. As to bond.
Today we are stepping straight into a courtroom where things escalate almost instantly. Within seconds, the defense requests a jury date, but the real tension begins when the judge brings up bond. Then comes the key moment. Mr. Smith's bond has already been revoked. That single detail flips the tone completely. What seemed procedural suddenly feels serious. There's no build-up, no delay, just immediate stakes. You can sense this isn't routine anymore. Something has already gone wrong before we even got here. And now, the courtroom is about to unpack it in real time.
Your Honor, I believe Mr. Smith's bond was revoked at his prior hearing on Thursday at PCC hearings. Since then, I've attempted to reach out to supervising agent at Community Corrections to answer questions that the court had concerning the violation. Specifically, my information is that Mr. Smith received word that he had been in violation at 1:50. At 1:58, 8 minutes later, exited the exclusion zone, Your Honor. My information is from talking to Brian Casey, the supervisor over at Community Corrections, that it was the supervising agency that reached out to him, but he was under the misplaced perception that he was talking to Mr. Brian Levitt, the supervising agent, but instead it was JSG, I believe, supervising agent for the tether company that he was speaking to in reference of the violation and his need to get out of the exclusion zone, in which he immediately did. My further information is that
8 minutes after being in, he got up.
and he was not in contact with the complaining witness. My information is that he went there to assist a family member, a cousin who was moving, and he needed to get some money. And the reason that he went there was to assist in moving. But once he found out that the address that the cousin was moving from was within the exclusion zone, he left. No contact with the complaining witness whatsoever, Your Honor. My further information is that I'll leave it at that right now, other than he needs to get out to assist with child care. Is that what you told me?
Yes,
Child care, as it relates to a child in common with the complaining witness.
Yes, sir. Your response, MP.
At this point, I'm going to object. This violation of the exclusion zone is extremely concerning to people, given that this domestic violence case occurs at where the exclusion zone is. Then he picks up another felony case for assisting and obstructing at that same location. And I have concerns now that he's going back to that area. He's there for 8 minutes, and I don't know if he contacted his actual agent rather than just the JSC. It's not in the report, and he was there for 8 minutes.
I attempted to contact the supervising agent on Friday, but was informed that he was out of the office. Again, this morning before court, I went over to Community Corrections. The supervising agent wasn't available, and I spoke to his supervisor, Brandon Casey, and I relayed the information from the notes, I believe, in the supervising agent's file through Mr. Casey. Your Honor,
Yes.
is he on remand or is there a cash component right now?
Cash component.
Would you consider a cash component?
Not at this time. What I will do is his bond will continue as revoked.
The prosecution steps in firmly, calling the violation extremely concerning, especially because it ties directly to a domestic violence location. That instantly raises the stakes beyond a simple technical mistake. The defense tries to soften it, but the narrative is shifting fast. The judge begins questioning, weighing both sides carefully. You can feel the skepticism growing. Then comes the turning point. The judge decides the bond will remain revoked. It's a controlled but powerful moment, showing that even brief violations can carry serious consequences in court.
given the violations that the court sees. However, I will set a pretrial or a bond hearing for May 4th, 2026 at 12 noon. And you can provide the additional information if you get it.
Would that be can we sign the waiver right now?
Sign what waiver?
Oh, I'm sorry. I misspoke.
Thank you.
He's,
Yeah. The one. Great. Joe's here, Bernstein's here. Oh my goodness.
I bet it's gonna be super quick.
What?
I'm at
Southern Michigan court rules, they're the cases decided there under. To the extent of conflict does exist, given the waivers, court will consent to hear this. All right. Mr. Brown, we have a bond violation.
yes, Your Honor, I've shared it with my client. He will admit that he tested late on the dates contained in the report from April 15th, authored by Community Corrections Supervising Agent Charles Mormon. I can give the court some background.
Go ahead.
Present here with his mother, who took her time out of her day to come see about her son. What was going on with him? He was working at, I believe it was Burger King on Stadium, Taco Bell on Stadium, and he worked 4 night shifts and 2 morning shifts, and his biological clock was thrown off by some of those hours. So, for example, he'd get off work 3 or 4 in the morning, and then he was supposed to test between 4 a.m. and 7 a.m. and fall asleep. But he'd wake up and then he'd test, and his tests were negative for any controlled substance.
Why did
Now,
he test it? I mean, there's a 3-hour window.
you sleep after working a shift at kid, 24 years old, Your Honor.
But we had sent to him, I mean, there were times before this at the problem. And we had sent an order to comply to him back on March 9th. So not taking any action. And then he was good for about 10 days. And then proceeded to have 1, 2, 3, 4, 5, 6, 7, 8, 9. It's test.
Missed, but they were compliant. No alcohol. If we're on page 2.
I understand there's no alcohol, but I could consider these violations. He's supposed to test in that time window.
And I've impressed that upon him, Your Honor. That's why he's here. Also, he's now left Taco Bell, and he's at doing landscaping, and he's advised his agent. So they adjusted or tried to accommodate his work schedule, landscaping now. And I have his works.
How is that going to work? Landscape. That could be even more problematic.
I talked to him about that, but he thinks that he's worked it out with his agent so that they now have a plan so that he's going to comply and test during the windows that you've ordered.
Anything from the people?
the court indicated the court is quite clear, even on the April retrial, there's not to be any more late tests, and unless we've gotten us late tests, I think the best way forward is frame tether. That way there can't be any late tests, and we continue monitoring the defendant.
In his defense, Your Honor, he was seen by Mr. Statman and got his assessment on April 17th. So we are trying to move forward with the case. We're not dragging our feet, and I'm not changing the subject, but he's got a new job and he's trying to do better. And he's got his mama here in court today. Ma'am?
Oh, I see her. All right.
Did I miss anything? Okay.
Only there was some time that he wasn't able to change the testing schedule when he switched jobs and switched schedule. I think that was an issue.
And ma'am, for the record, what's your name? Sarah Ladd?
Mother's Day is coming, Judge.
What am I supposed to do with that?
Mother's Day is coming. I mean, it says a lot. She's standing up for it.
I get that, but I mean, I've got 14 missed tests.
Yes, Your Honor. But no alcohol. She'll tell you he's not drinking.
The judge directly confronts the defendant, questioning why jail shouldn't be the next step after repeated violations. The tension is undeniable here. The defendant tries to explain work schedules, exhaustion, staying away from trouble, but the judge isn't easily convinced. It feels like the final chance slipping away. Then comes the twist. Instead of immediate jail, the judge offers a strict alternative scram tether monitoring. It's a narrow escape, but with heavy conditions. This moment perfectly captures how quickly things can turn and how close the line is between freedom and incarceration.
Young man, when you got the order telling you to comply and no more late tests, and when I told you at court no more late tests, what were you thinking?
To just try and get them on time. Try to not go for any more late ones, but sometimes I just lose track of time when I'm at work. Most of these have only occurred when I'm physically at work.
Young man, tell me why I shouldn't just throw you in jail. You don't listen to the court's order. That's 2 orders you haven't listened to. Yeah, the first order telling you to test, and then I sent you another order telling you to comply.
Well, I don't think I should be put in jail because I'm besides being late, I'm complying with everything else and doing exactly what I need to be doing. Not touching drinks, just working and doing what I need to do.
What about your association? Still hanging out with the same people you're drinking with?
No.
What I'm going to do is, defendant having admitted to violations, I'm not going to incarcerate you at this time yet. But you're going to go over to community corrections, get placed on the scram tether. Any types of violations, such as not being charged, not properly downloading, all of those things. If you don't follow that to a T, you're going. Am I understood? I didn't hear you. Thank you.
Yeah.
Do you have the unit with you?
Yeah.
You take that over and they'll fit you with the scram tether.
Okay.